One way to understand this presentation here is that we all participated in choosing entry points to that work, which then became, to some extent, chance-based. And as this rhythmatic network spread, it also spread a bit by chance in space here. Now, I think this is a good model to start to understand from Percept the conceptual legal framework performance in the way that it is done in collaborative and improvised ways. Not only is it the case that the meaning of what the talk was influenced by the order of events, how the rhythmatic network spread out, but even more importantly, the meaning of what he said has to do with meaning generated in other points and instances in time and space. Beckett, Lord Chamberlain, a wide range of historical situations, plays, and other things. All these things, through the text, we connect to, and they generate the meaning that this presentation is about. So the question is then, what is this work?
Exactly.
Well, Beckett's work is part of this work. It generates meaning to this work. Lord Chamberlain's historical, political, legal situation generates meaning to this work. And this work generates meaning to those situations. Paraphrasing Donna Haraway here, it's almost like we have these wormholes in the space-time network. And the work operates by passing through these wormholes. Another way to understand this is that we have all these entrance points, as I mentioned before. Entrance points to the work. One entrance point is Lord Chamberlain. One entrance point is Beckett's play. One entrance point is the color of the paper. All these entrance points that we create, it's the text that they read. But the work itself, what is that? I think this is a crucial question here. Thinking of this as Dee was reading a little text I wrote about the virtual versus the actual. If we think of, in Deleuzian terms, the virtual is a realm that is always existing, always present. It doesn't have a past, present, future. That appears as something is actualized into the actual. But if we think of those wormholes in space that I created, or these entrance points, that they're creating this dynamic pattern of resonance that happens in the virtual, and we have these taps, shall we say, where we pull out actualizations of the work, which are these connection points of the line. Now, one may argue from the perspective of copyright, existing copyright and performance rights frameworks, that, well, surely what I'm talking about is just an obsession about appreciation. Really, what I'm talking about is just appreciation, that we look at the work and we interpret it in different ways. Well, perhaps that may be the case. However, looking at that argument from the perspective that I just suggested, that you have a work in the virtual world, which is not past, not present, not future, it coexists, and we plug into that and tap it out, actualize it through our individual entrance points, then it appears that which we today call a work which is protected by the legal framework is just another entrance point. It is just yet another actualization of the virtual, another wormhole in the space-time fabric, as it were. The problem with that is that that particular wormhole or set of entrance points tries to position itself not just to marginalize other entrance points, but it tries to position itself as the work, when it equally could be argued that it is just an entrance point towards the work. And I think that it is, if we look on Michael's idea of a computer program here, for instance, what is the work? Well, as we mentioned before, the legal framework says possibly it is the music that is created, is the performance of the music, but we could equally argue that it is that computer program. This is just an analogy, I would like to say, because from a Deleuzian perspective, that computer program is itself, there's nothing virtual about it, it is still yet another actuality, which then is another wormhole or entrance point into the virtual of that work. But it's a good analogy how to relate and think about these things here. And I guess this is a product. It is a suggestion for a productive way, I think, where one could start to think about the relationship between processes that plugs in and out of something, and how that sometimes actualizes into set-specific works, videos, music, performances, perceptions of these things.
Thank you.
Something like that.
Thank you very much.
Can I just go in your usual Deleuzean way? How, if we're thinking about that kind of talk, if you like, that kind, because it's quite difficult to grasp it, I think, in certain ways. And we're talking about the possibility of how we then engage with policy workers or people who are engaged in copyright or whatever. How is it possible to make sense of that in those other contexts?
I think it comes to loosening, it comes back to Roland's loosening the rights of the copyright in a way to allow those creative interventions to regenerate the work. I mean, my last thing there about Alistair McLennan's performance, this is just the tip of an iceberg of what's happening in live art, which is remediation of works that actually weren't very much documented. It's an attempt to somehow connect with the ephemerality of the live artwork and allow it to be restaged, which is a curious paradox, because the point about the live work is it happens once and it's not restageable. But folk are connecting this to the archive and thinking, we don't have an archive of live practice, what do we do about that? And rather than going back and simply getting photographs and putting them into an archive, what they're doing are quite creative ways of engaging and collaborating with anyone. Anyone could donate a performance memory. So most of the memories are not from performance practitioners, they're from spectators. I don't work in copyright, so I actually don't know if I have... It's a memory, it's not Alistair's, it's my memory. There's nothing wrong with that, you know, that action. It's quite interesting. What I'm doing is performing my memory of his work. But in a way, that's another, my version of Mel is now circulating in an exhibition. Sorry, I don't know the answers, but something about loosening up in a way.
I also think it has to do with, it's a question of how we conceptualize work. The idea that what we today call the work may just be one particular access point to the work. And to realize that, shall we say, relative inaccessibility from the current perspective. And not to impose that particular access point as the overall dominating one that excludes other.
It's a very, just to comment, it's a very radical attack on the legal order or any concept of order. And I mean, your memory was a misremembering. So,
well, if we assume that document is the real document, I don't know that it is.
Well, exactly, we don't know. Yeah, it's not authenticated.
No, and also it might have been posed for the camera.
Yeah.
By the time he came to do the performance, he might not have felt too.
Maybe just found another shoe.
Maybe.
But I suppose what the answer to Helen would be. It would be impossible for law and policy to accept the infinite regress. So the argument is then going to be how much do you loosen up and retain some kind of rule-based framework. I think that's the best I can do. But it's a very sort of radical attack. I think.
But for me, in a way, it comes back to the ethics, though. What's it ethical? I mean, in terms of my practice, what is it ethical? What do I feel is ethical? I know that's another. It's sort of glancing it sideways into another whole problematic area, because ethics is such an individualised thing. But what was it ethical for me to do to this performance? It wasn't ethical for me not to do it with a sense of integrity, a sense of serious commitment to the action that I was reenacting. The photograph itself looks beautiful, I think. I don't know. Sorry.
Well, I was just going to say that we could spend the rest of the day unpacking what's just happened and talking about it within a copyright framework. But there's an interesting, a recent case in Germany about exactly this. It was a Joseph Beuys performance piece in the late 60s that was broadcast, so not fixed. It doesn't have to be fixed in Germany. And it's not clear that artistic works have to be fixed in the UK either to be copyright protected. We know this, but. So it wasn't fixed. There was somebody there, the photographer whose name I can't remember, was documenting it, took a series of photographs and wanted to exhibit them last year. And the German court ruled that the Beuys performance was a protected work of art and boy's widow refused to grant rights to. So these things, until Boys comes out of copyright, presumably will never be seen. And that's appalling as far as I'm concerned in terms of documenting events like this. Whether a court in the UK would reach the same result, you know, is a matter of debate, but it's a very real example of the weight of the intellectual property regime and how it brings to bear upon these kind of contemporary I've forgotten the word that you use.
Remediation. That's and I think it's quite interesting, remediation in relation to copyright and what that does to copyright, actually, remediating live works, not by the originator.
Was this a work of art? Arguably, yes.
Oh, Ron and I like to think so.
Arguably, yes. Does it matter that it wasn't fixed?
Well, there is a
script.
it was fixed. Well, it's documented.
It's documented,
so
of course. You're good to go. That's fine.
That's a very good note on which to go for coffee, I think. And then